So hello everyone, welcome to Bajirao IAS Academy. So we have been discussing polity important topics for mains examination, and last few classes we have discussed some important topics with respect to separation of powers, basic structure doctrine, and other important topics in polity. And today we also have another very important topic, that is parliament and state legislature. And from this particular topic you could at least expect one or two questions in your mains examination. So therefore we will try to understand the parliamentary form of government in India, and in fact, so what are the major factors which have been affecting the productivity of the parliament, including both Lok Sabha and Rajya Sabha. And we will also understand the office of speaker and deputy speaker as well. And in fact, the office of speaker is also very often in news because the speaker is from the ruling party, right? So in fact, most of the speakers are not resigning to the party membership when they are elected as the speaker of the Lok Sabha. And this has been very often leading to the biased position taken by the speakers when it comes to passage of bills or introduction of bills. Now in this context, we will be understanding in a very detailed manner the functioning and the powers, responsibilities of the parliament as well as the state legislative assemblies or state legislatures. And in fact, India is known as democracy, and we very often call our democracy as a functional democracy. However, in order to strengthen and sustain democracy, parliamentary form of government plays a very important role. And in fact, the essence of democracy is upheld by the parliament and also the state legislatures. They can actually uphold the democracy. And in fact, India is called as a functional democracy and also world's largest democracy. And after our independence, so India still a successful democratic country despite the apprehensions and pessimism about India's democratic transition. And in fact, the parliament and state legislatures played a very important role in upholding constitutionalism, constitutional morality, and constitutional values in India. The primary function of the parliament is law making. So parliament is endowed with the function of law making. And in fact, parliament also plays a very important role in holding executive accountable, and it is also known as the body which has been representing the will of the people. Because in the Lok Sabha, which is also called as the lower house, the representatives are directly elected by the people. However, in the Rajya Sabha, the members are indirectly elected by the people. So together, we could call that the parliament has been representing the will of the people, and it also holds the executive accountable, because it is said that the Council of Ministers are collectively responsible to the lower house of the parliament. Now, we will try to understand some features of parliamentary form of government and why Indian constitutional framers have preferred the parliamentary form of government over the presidential form of government. We'll try to understand this. So there are some reasons for preferring the parliamentary form of government. So first we'll try to understand what are the features of the parliamentary form of government. The first very important feature is a nominal and real executives. And in fact, in a parliamentary form of government, it has both nominal executive as well as the real executive as well. And in fact, in India, president is known as the nominal executive and the real executive is the prime minister. And in fact, prime minister is also known as the head of the government, and president is also known as the head of the state. And in this context, president serves as a de jure executive. So it also means president serves as a nominal executive. But on the other hand, prime minister serves or functions as a de facto executive or a real executive. In a parliamentary form of government, real executive is the prime minister and nominal executive nominal executive is the president. So therefore, in a parliamentary form of government, there is both nominal executive and real executive. So secondly, the majority party rule is also the feature of parliamentary form of government, because general elections takes place once in 5 years in India, and after general elections, whichever party gets the majority in the lower house, that particular party can actually form the government. So therefore, parliamentary form of government also has another feature of majority party rule. So a political party with a majority in Lok Sabha forms the government. So therefore, it is another very important feature. And third, collective responsibility. So when we talk about the collective responsibility, so as I have already told you that there is a separate article 75 of the Indian Constitution, right? So Article 75 of the Indian Constitution talks about the collective responsibility of the Council of Ministers to the Lok Sabha, right? So in this context, collective responsibility is also the feature of the parliamentary form of government, right? So in fact, double membership. So what does this double membership actually means? For example, whenever a minister, whenever a council of ministers is being formed, so in this council of minister, the ministers are actually the members of the legislature. So members of the legislature can actually become the ministers. The council of ministers, all the ministers are the members of the legislature, either Lok Sabha or Rajya Sabha. And the other provision is that, so any one minister or any of these ministers who are part of the council of ministers can also become ministers without being a member of either house of the legislature or either house of the parliament, right? So even without being a member of Lok Sabha or Rajya Sabha also, anyone can actually become the minister, but provided that after 6 months of becoming a minister, the person must become a member of either Rajya Sabha or Lok Sabha, right? So this is what is known as dual membership or double membership. So double membership in the sense that the member of legislature can become a minister. So here he is a minister as well as the member of the legislature as well, and this is known as the double membership. And in fact, in the parliamentary form of government, Prime Minister is known as the head of the government. And in fact, Prime Minister is considered as a central figure in the parliamentary form of government, and this is another major feature of the parliamentary form of government. And in fact, dissolution of lower house. So what does it mean, the dissolution of lower house? In fact, this is also a feature of the parliamentary form of government. And in fact, Lok Sabha can actually dissolved by the president. The powers to dissolve Lok Sabha has been given to the president, and in fact, the dissolution should be recommended to the president by the prime minister. So if prime minister recommends president to dissolve the lower house, president can actually dissolve the lower house and fresh elections can be held. And in fact, in parliamentary form of government, the other major feature is political homogeneity. This essentially means the members of the council of ministers, they typically belong to the same political party, and it actually ensures the ideological consistency. And another major feature is secrecy, because ministers are bound by the principle of secrecy of procedure, and they cannot divulge information about their proceedings, policies and decisions, and these are the major features of the parliamentary form of government. And in fact, whenever you are being asked a question to mention the parliamentary form of government and its major features, you should mention all these important features. And secondly, reasons for adoption. Why parliamentary form of government has been preferred by the constitutional makers, and this is very important that we should try to understand this, right? So in fact, the reasons for adoption of the parliamentary form of government including the familiarity with the system, right? Because we were under the colonial rule from up to 1947, and in fact Britain was one of the country which has actually colonized India, and we were under the control of Britain till 1947, and British have the parliamentary form of government. So therefore we have adopted this parliamentary form of government from British. So since we have familiarity with the parliamentary form of government, right? So in fact, it has a huge British influence when we have adopted the parliamentary form of government. And in fact, the Government of India Act 1935, Government of India Act 1919, Government of India Act 1909. So all these different legislations actually talks about the parliamentary form of government. So out of that particular experience, we have the parliamentary form of government in India after our independence. And in fact, Dr. B.R. Ambedkar, so he played a very crucial role when it comes to framing Indian constitution, and Dr. B.R. Ambedkar actually preferred responsibility of the Council of Ministers to the lower house. In presidential form of government, it is generally absent. And in fact, Dr. B.R. Ambedkar rightly highlighted the need and the importance of democratic executive to exhibit both stability and the responsibility, right? So in fact, avoidance of legislative and executive conflict is another major reason that has driven the parliamentary form of government. So it is less likely in a parliamentary form of government to minimize, avoid the legislative and executive conflicts between these two branches, because that could effectively stalls the governance and the administration. And in this context, we have some important constitutional provisions. So you kindly go through all these important constitutional provisions, because whenever you write answers, it is very important that you should mention these constitutional provisions as examples. And those examples would certainly enrich your answer. For example, Article 2079 of the Indian Constitution. So it has actually established the bicameral parliament, right? So it has established what? It has established the bicameral parliament. Now, what is a bicameral parliament? In India, parliament consists of both Rajya Sabha, which is also known as the upper house, and it also consists of Lok Sabha as well. So therefore, Article 79 of the Indian Constitution provides for the bicameral parliament. And similarly, Article 80 of the Indian Constitution talks about the composition of Rajya Sabha along with the system of proportional representation by the single transferable vote. So this is how Rajya Sabha members are being elected. And in fact, Lok Sabha members are being elected by the first past the post system. So they are being elected by the first past the post system, and Rajya Sabha members are being elected by the proportional representation and single transferable vote. And similarly, Article 74, this is also a very important article, and this article talks about the Council of Ministers, and those Council of Ministers are headed by whom? They are headed by the Prime Minister to aid and advise the President. So Council of Ministers headed by the Prime Minister, so they provide advice to the President. And similarly, Article 75 of the Indian Constitution talks about the collective responsibility that we have just talked about. And in fact, collective responsibility is one of the main reason for preferring the parliamentary form of government, because here executive or the Council of Ministers are collectively responsible to the legislature, and there is a higher possibility of holding executive accountable to the legislature. And this is another major reason why parliamentary form of government has been provided in India. And similarly, another very important article, Article 93 of the Indian Constitution, and this article talks about the office of the Speaker and the Deputy Speaker, and it also mandates election of the office of the Speaker and Deputy Speaker from among the members of Lok Sabha. And similarly, Article 102 of the Indian Constitution, it talks about the disqualification of the members of the Rajya Sabha. Right? So disqualification of members of the parliament. For example, office of profit. So office of profit, so it is a one ground based on which the members of the parliament can be disqualified. And apart from that, the 52nd constitutional amendment also, we have the 52nd constitutional amendment talks about the anti-defection law. So we actually discuss about this anti-defection law later, but Article 102 of the Indian Constitution talks about the disqualification of the parliamentary membership and criteria that it actually provides. And another very important article, Article 368 of the Indian Constitution, we already discussed about this. It talks about the amendment of the Indian Constitution. So Constitution can be amended under Article 368. So it can be amended with the simple majority and a special majority, and special majority with the consent of the half of the state legislatures. And in a similar manner, for state legislature also, we have a very important provisions, and that deals with the state legislature. And in fact, understand, under 7th schedule of the Indian Constitution, powers are actually devolved, or powers are actually distributed between the union government as well as the state government. And in fact, these powers are constitutionally distributed powers between the union government and the state governments. So like at the union level, how parliament make laws on different subjects which are mentioned in the union list and concurrent list in the 7th schedule. In a similar manner, state legislature also make laws on 7th schedule, particularly state list and also the concurrent list subjects. So therefore, it is also important for us to understand the powers of the state legislature and the constitutional provisions that deals with the state legislature and executive. First article is Article 163 of the Indian Constitution. Again, it talks about the Council of Ministers, who are headed by the Chief Minister to aid and advise whom? To aid and advise the governor. In a similar way, Article 164 talks about what? So it actually outlines appointment of Chief Minister and also the Council of Ministers by the governor. Right? So it talks about the appointment of Chief Ministers and Council of Ministers by the governor. And in fact, governor appoints Chief Minister and governor also appoints Council of Ministers on the recommendations of the Chief Minister. And another very important article, so that is Article 168 of the Indian Constitution, and it actually mandates a legislature in every state. There should be a legislature in every state, and the basic responsibility of legislature is what? It enact laws. And in fact, the executive actually execute laws and judiciary adjudicate laws, but the function of the legislature is enactment of laws. And Article 168 of the Indian Constitution provided for the legislature in every state. It could be either unicameral and bicameral as well. So unicameral in the sense that most of the state legislatures have only the state legislative assembly, but there are some states also which have the state legislative council as well. For example, Andhra Pradesh and Telangana, Maharashtra, Karnataka, Bihar, UP, right? So these are some states which have the legislative council as well, but all states don't have the legislative councils, but almost all states have the state legislative assemblies. So therefore we could interpret that at the state level the structure of the legislature could be either unicameral or bicameral. And article 169 of the Indian Constitution deals with what? So it deals with either creation or abolition of legislative councils. The power of creating or abolishing legislative councils is with whom? So it is with the parliament. Parliament can actually create or abolish the legislative councils, but the state legislative assembly has to pass a resolution either for the creation or abolition of the state legislative council, and accordingly parliament through a constitutional amendment, even though it is not considered as a constitutional amendment, creates a state legislative council as well. And similarly, another very important article, so article 191 of the Indian Constitution, and this particular article deals with the disqualification of membership or disqualification criteria for the membership to the state legislature. Similarly, article 178 of the Indian Constitution, it calls for the election of a speaker and deputy speaker among the state legislative assembly members. And article 200, it actually stipulates certain bills that must be signed by the governor to become an act, and it also outlines important discretionary powers of the governor. And remember, governor also enjoys two types of discretion. So one is the situational discretion and the other is the constitutional discretion. So these are two different types of discretions that the governor actually enjoys, right? So these are important constitutional provisions. And now we'll understand what are the basic functions of the parliament in India. So parliament actually perform some basic and important functions. The most important function that parliament perform is what? Lawmaking. So lawmaking is considered as the most important function that parliament performs. So parliament is actually responsible for making laws, amending the existing laws, and also making changes, alteration to the Constitution of India. And in fact, this is considered as a very important task because it shapes the legal and policy landscape of India. And therefore, lawmaking is considered as a very important function of the parliament. And in fact, parliament also holds executive very often accountable. Now, how parliament holds executive accountable? Because we have already understood article 75 of the Indian Constitution says that the council of ministers are collectively responsible to the lower house. They are collectively responsible to whom? So they are collectively responsible to the Lok Sabha, and because of that particular reason, parliament can actually hold the council of ministers accountable through various through various elements such as no confidence motion. So no confidence motion, question hour, 0 hour. So these are some mechanisms which are being available with the legislature to hold the council of ministers, which is also known as executive accountable, because as I have already told you that the council of ministers are collectively responsible to the Lok Sabha, and therefore the Lok Sabha or the lower house or the parliament can hold the executive accountable using mechanisms such as no confidence motion, censure motion, and also the question hour. And apart from that, legislature, along with enacting laws and also performing the duty of holding executive accountable, it also performs certain judicial functions. And what type of judicial functions it actually perform? It exercises the quasi-judicial powers and those quasi-judicial powers including formation of inquiry committees, impeachment process of the president, removal of judges of the high courts and the Supreme Court, and also upholding the parliamentary privileges under Article 105 of the Indian Constitution. And these functions which are performed by the legislature or the parliament are called as judicial functions. Because don't you think that parliament actually has the power, or parliament actually plays a very important role when it comes to the impeachment of the president, removal of the judges of the high court and Supreme Court, and also upholding the parliamentary privileges as well. And similarly, the legislature or the parliament also perform the election function as well, because parliament participates in the election of president, in the election of vice president, internally also elects chairperson of each house and heads of various parliamentary committees as well. So therefore we could say that parliament actually performs the judicial functions. It also performs the election functions, and it also function as a body for the management of the finances. Because one thing that you need to understand here is that executive cannot withdraw or use funds from the consolidated fund of India. So if executive wanted to withdraw funds from the consolidated fund of India, so executive must require the approval or the authorization of the parliament. And in fact, budget is presented before budget is actually introduced before the parliament, and it will be scrutinized by the various committees of the parliament, such as Public Accounts Committee and Estimates Committee. And in fact, if government wanted to withdraw money from the consolidated fund of India, so government must require an approval or authorization from the Parliament of India. So therefore, don't you think that parliament also manages the finances of the country? However, Indian legislature has been facing number of issues, so it is not free from the issues, and we'll try to understand what are the issues that Indian legislature has been actually facing. The first issue it has been facing is the decline in the number of sittings. So this is the first major issue. And in fact, the 16th Lok Sabha, right? So 16th Lok Sabha actually sat for a total of 1615 hours. So that is a significantly less than the average of a full term Lok Sabha. So therefore it has been indicating that in fact the number of sittings, the productivity of the Lok Sabha, and overall functional efficiency of the parliament has been substantially declining. And discipline and decorum is another major issue that has been faced by the Indian parliament. So parliament has been losing valuable time due to disruptions and indiscipline among the members as well. And similarly, declining the quality of parliamentary debates is also another major reason as well. So therefore, instead of focusing on important national issues, parliamentary discussions have increasingly centered around the local issues and political rivalries. And parliament has also become a platform of political rivalries or platform of fulfilling the political agendas instead of working for the collective national interest. So that is being absent, and constructive criticism of the ruling party is also absent in the parliament. And in the parliament also we very often see healthy and productive discussions recent times. So this also indicates there has been an institutional decline in the functioning of the parliament. And similarly, in recent times, since independence, the number of women representatives in the parliament has not substantially improved. And in fact, the last Lok Sabha the last parliament or last Lok Sabha, it is just around 14%. So however, it is still substantially lower compared to the global average, even compared to the least developing countries or even India's neighboring countries. So therefore, there is an immediate and urgent need to substantially increase women's participation in the parliament. However, through 106th Constitutional Amendment Act, the Nari Shakti Vandana Abhinayam has brought in 33% reservation provision for women in the state legislature, as well as the Lok Sabha as well. So however, it is expected that this 106th Constitutional Amendment Act would substantially increase the representation of women in the parliament, and it would also change the perceptions and attitudes among people and within the society about the political representation of women, and it is expected that it will lead to the empowerment of women on a large scale. And another major issue that parliament has been facing is inadequate discussions that have been taking place, because bills are often passed with a minimal discussion and they are often by voice vote only, and that leads to lack of transparency and even debate as well. And similarly, in parliamentary committees such as Public Accounts Committee, Estimates Committee, in most of these parliamentary committees there is a reduced scrutiny, and reduced scrutiny is because of absence of expertise. Absence of expertise is one reason, so which has been leading to the inefficient scrutiny of the bills which are introduced in the Lok Sabha or in the parliament. And apart from that, legislation through the ordinance, and in fact the president under Article 123 of the Indian Constitution can actually pass an ordinance when both houses of the parliament are not in session. And similarly, through Article 213 of the Indian Constitution empowers the governor to issue an ordinance when the state legislature is not in session. However, in recent times, the executive has been following the ordinance route to pass laws or to enact laws, because the ordinance also has the same force as a law that has been made by parliament. And because of that particular reason, ordinance is very often considered as a one means to bypass the normal legislative scrutiny or normal legislative debates and discussions over that particular bill. And ordinance making is also becomes easier for the government, because president at the union level and governor at the state level, they actually work as per the advice tendered by the Council of Ministers. So in recent times there has been an increased use or misuse of the ordinance making powers as well. And in fact, uncodified parliamentary privileges under Article 105 of the Indian Constitution is another major issue that has to be tackled with. For example, countries like Australia have already codified the parliamentary privileges, but in India these privileges are not yet codified. So therefore, when these parliamentary privileges are not codified, there is very high chance of misuse of these parliamentary privileges. For example, Article 105 provides certain privileges for the members of the parliament, right? So in fact, one such privilege would be freedom of speech and expression for the members, and those members cannot be arrested during the parliament is in session. So such privileges are being provided, and it is very important to have a clarity on all these privileges, so that could prevent the misuse of these privileges. And in fact, very often, because of the majoritarian governments and speaker is from the ruling party, so bills are very often passed through the money bill route. And in fact, with respect to the money bill, Rajya Sabha has the limited role. Rajya Sabha has a limited role. So it is the duty of the speaker, or whatever speaker says with respect to money bill is final, and Speaker of the Lok Sabha decides whether a particular bill is money bill or not. So if Speaker decides a particular bill is money bill, so it will be passed in the Lok Sabha and then it will be transferred to the Rajya Sabha. And in fact, Rajya Sabha cannot reject the money bill, and Rajya Sabha can just suggest the amendments or suggest some recommendations to the money bill that has been transferred to by the Lok Sabha to the Rajya Sabha. So even if Rajya Sabha don't take any decision on the money bill within 14 days, then also this money bill is considered as passed by the Rajya Sabha. So therefore it clearly indicates that Rajya Sabha has limited role with respect to money bills. So therefore resorting to money bill is also another major concern in the parliamentary form of government. I hope you have understood this. However, there are certain suggestions for bringing in the parliamentary reforms. So what type of reforms are required and what type of reforms have to be brought in? For example, there is a need to fix minimum number of sittings, right? So it is very important that there should be a minimum number of sittings for the parliament in one single sitting, one single session, or even one single year, right? So it is recommended that there should be 120 minimum sittings for the Lok Sabha and 100 minimum sittings for the Rajya Sabha, because that could substantially increase the parliament's productivity and also the functioning of these two houses of the parliament as well. Similarly, it is very important to codify all the privileges which are mentioned under Article 105 of the Indian Constitution. So as of now, the members of the parliament are enjoying certain privileges, but these privileges are not codified properly, and since they are not codified properly, it could create a lot of confusion, and it would also have the scope of in fact misuse of these parliamentary privileges as well. So misuse of parliamentary privileges is not good for a healthy democracy like India. So therefore there is an urgent need to codify parliamentary privileges. So as I have already told you that other countries like Canada and Australia have already codified their privileges, so therefore in India also the parliament has to codify all the privileges, and similarly strengthen departmental committees and also the accountability as well. So in this context, improving the functionality of departmental committees, because there are a lot of departmental committees which works within the parliamentary system. So therefore provide expertise support, improve the functionality of the departmental committees of the parliament, because that could further enhance the valuable insights which are provided by these departmental committees into the government's working, and it would substantially enhance the accountability of the government to the legislature. So ensuring accountability of the executive to the legislature is very important and crucial, because it could check arbitrariness of the government, it could check the majoritarianism of the government as well. And similarly, it is very important to improve the quality of legislation. So any legislation that should not be arbitrary, that should not be against the democratic principles, and any legislation that should not curtail the civil liberties of the people. So therefore we need to improve the quality of the legislation. So along with better utilization of the law commission, that can actually enhance the quality of legislation in India, and even we need to enhance information supply for the members as well, because as of now it is said that most of the members are not having adequate information. So therefore the members of parliament updated with the developments in areas of parliamentary concern, and that could substantially improve the quality of debates and also the decision making as well. And similarly it would help reduce the expenditure as well. So reducing the expenditure of the parliamentary functioning is very important. For that reason, enforcing strict controls in parliamentary spending can actually make the institution cost effective as well, and improve the quality of the members. It is very important that we need to improve the quality of members. For that, setting a strict code of conduct for the members, particularly those on important parliamentary committees, can improve their quality and also their performance as well. So, and similarly, there are some other important suggestions which are actually provided for the efficient and effective functioning of the parliament. So those suggestions include improve the public image of the parliament. Now it is expected that most of the people are losing the trust over the democratic institution, that is Indian Parliament. So Indian Parliament is also known as the temple of democracy, but because of declining productivity and declining the number of hours Parliament working, and apart from that, Parliament is very often used to serve the personal political agendas of the political parties, and they are not actually discussing the problems which are national concern. So it has led to the decline of public image about the Parliament. So therefore, access to public opinion and also fostering a better relationship with public can substantially improve the Parliament's image. And even training for the members is also very important. So as of now, there is no provision for providing training to the members of the Parliament. However, it is expected that there should be a professional training, and that has to be imparted to the members of the Parliament, and orientation to the newly elected or nominated members, because that could substantially enhance their effectiveness. And it is also important to use technology for virtual meetings, such as leveraging technology for virtual meetings, so that could further result in a legislative work continues during crisis like the COVID-19 pandemic, because during COVID-19 pandemic lockdowns were imposed, and those lockdowns never made holding parliamentary sessions easy, right? So we were not able to conduct the parliamentary sessions during the COVID-19 pandemic. But if we leverage the virtual digital technologies, even during crisis situations also, we could actually hold the parliamentary sessions very regularly. And introduction of the legislative impact assessment is also another very important suggestion, right? So because the legislative impact assessment can actually improve awareness and legal evaluation of the proposed laws. And even formation of the shadow cabinet. So shadow cabinet, this can actually strengthen the role of the opposition, because shadow cabinet is a practice which is followed in the British parliamentary system, but it is not followed in Indian parliamentary system. But legal experts have been suggesting that India should also form a shadow cabinet as well, because this could further strengthen opposition, and opposition starts playing a very important role in further strengthening, further enhancing the democratic functioning as well. So however, the journey towards a robust and responsive legislative system actually requires a persistent, long-term, constructive efforts, dialogue, and also unwavering commitment and determination to the democratic values. Now, you could actually use this in your conclusion, so that makes your conclusion more and more effective, right? So in fact, we will understand the differences between the parliamentary and presidential form of government. So what are the major differences between the parliamentary form of government and presidential form of government? Remember that this is very important, because questions are very often asked on this particular aspect. Now in parliamentary form of government, so we see the dual executive that we have already discussed about this. Now what is this dual executive? So dual executive in the sense that we have a nominal executive and we also have the real executive. Nominal executive and the real executive. So this is what is known as the dual executive. And we have the majority party rule, the collective responsibility of the Council of Ministers to the lower house, and there's also a political homogeneity, because Council of Ministers are from a single political party. So this is also known as the majority party rule. So therefore there will be a more stability since all the council of ministers are from one political party and they have a common ideology. And in fact it also provided for the double membership. So what does double membership actually means? So double membership means that a minister is minister is also a member of the legislature, and a member of legislature will become the minister. So that is known as double membership. And leadership of the prime minister, dissolution of the lower house by the president on the recommendation of the prime minister, and also the fusion powers as well. So these are some of the features of the parliamentary form of government. However, what are the features of the presidential form of government that we see in countries like US? And in fact countries like Sri Lanka also have this presidential form of government, but the parliamentary form of government suits to India because of our colonial experiences. Now in presidential system there is a single executive, not the dual executive, and even president and legislators elected separately for fixed term. So there will be a fixed term. For example, you can see in US, Donald Trump, president of US, is elected for the 4 years. So there will be a fixed term for the president, and the president would not have the responsibility to the parliament. And there is maybe a political homogeneity may exist or may not exist, and there will be a single membership, not a dual membership, and a domination of president in the presidential form of government, and no dissolution of the lower house and separation of powers. And in fact understand one thing, that separation of powers is part of the presidential system of government. However, in Indian constitution also we have separation of power. The concept of separation of power has been implicitly mentioned in the Indian constitution itself. Now we'll understand the merits and demerits of both parliamentary system and also the presidential form of government. So the merits of parliamentary system including the harmony between the executive, legislature, and the responsible government. Government is accountable to the legislature, and it actually prevents despotism since government is responsible to the legislature, and wider representation, and it also prevent authoritarianism and even availability of the alternate government. So these are some merits of the parliamentary form of government. However, what are the demerits of parliamentary form of government? So parliamentary form of government is very often termed as unstable government because coalition politics so makes the parliamentary form of government the unstable government that we have seen during 1980s and 1990s in India. And in fact there is no continuity of policies because there is a lack of political stability, and parliamentary form of government is against separation of powers because one branch of the government very often interferes in the working of the other branch of the government in the parliamentary form of government. And in fact it is considered as a government by amateurs, and it is also leads to the dictatorship of the cabinet that we have seen during the Indira Gandhi regime. During Indira Gandhi's tenure, so we have seen the dictatorship of the cabinet. However, what are the merits of the presidential system? So a stable government is a merit of the presidential form of government, and in fact there is a definiteness in the policies of the government, and it is also based on a strict separation of powers between the different branches of the government, and it is not the government by the amateurs, rather it is government by the experts, and minimal influence of the party system in the presidential form of government. However, what are the demerits of the presidential form of government is that there is a conflict between the legislature and executive very often, and non-responsive government because executive is not responsible to the legislature, and it may leads to the autocracy and even the narrow representation as well. Right? So in this context we will understand the productivity dimension in the parliament. Right? Now what is exactly the productivity and how productivity has been declining in the parliament. So this dimension we'll try to understand. In fact, we all knew that parliament serves as a paramount democratic forum in the country. So India is a functional democracy, and the essence of functional democracy is the parliament. So therefore, parliament is also given credit for shaping destiny through debates, deliberations, decision making. So parliament is essentially called as the temple of democracy. So therefore, that kind of an importance has been attached to the parliament in India. So however, declining productivity in the parliament or the functioning of the Indian parliament is one major concern, and that is being evident from recent sessions, and that has further raised concerns about the effectiveness of this crucial democratic institution. Now, in this context, what are the reasons for the low productivity of the parliament? So there are certain reasons that could be considered as reasons for the lower productivity of the parliament. For example, increasing disruptions is one reason. Particularly, contentious issues such as Pegasus controversy, farm bills, inflation concerns, disagreements over various bills have disrupted recent sessions. And similarly, institutional decline is another serious aspect. Particularly, key positions such as Deputy Speaker of Lok Sabha, Leader of Opposition have not been filled despite the constitutional requirements. And similarly, inadequate time for the opposition is also another major reason. So remember that Speaker is from the ruling party, right? So in most recent times, the healthy convention of resigning before being elected to the office of the speaker is also not followed by the most of the speaker. So therefore, speakers are very often taking biased stand in favor of the government. So therefore, that leads to giving inadequate time for the opposition political parties, and the opposition members have been very often expressing their dissatisfaction over the insufficient time that has been given to them to air their grievances. And in fact, the unresponsive government attitude is also another major reason, because there are instances like refusal to form the joint parliamentary committee on 2G scam. So all these things have triggered a lot of disruptions in the functioning of the parliament, right? So in this context, the violation of the parliamentary norms is also another major reason, because in recent times we have seen the indisciplined behavior of members of the parliament that we have particularly seen during the state bifurcation, Andhra Pradesh State Bifurcation Act, and in fact members even sprayed the pepper spray on each other during that particular incident. And similarly, absence of prompt disciplinary action by the either speaker, deputy speaker, chairman or deputy chairman of either Lok Sabha or Rajya Sabha. So therefore, a lack of clear rules, a lack of action against disruptors actually encourages disorderly conduct by the members, and even insufficient time that has been given for unlisted discussions, right? So limited time for unlisted questions and objections also triggers a lot of disruption. So these are the major issues that have been creating new problems in the functioning of the parliament in India. So however, we need to understand some issues related to the working of the parliament. So parliament has also been facing some issues with respect to working of the parliament. So they include reduced proceeding hours in the parliament. For example, parliament's working hours have been decreasing, and that has been affecting the overall productivity of the parliament. And infringement of constitutional rights, for example, the curtailment of the question hour actually undermines the principle of parliamentary oversight over the executive, because remember that question hour is part of the concept of holding executive accountable to the legislature under Article 75 of the Indian Constitution. So therefore, curtailment of the question hour by the speaker or deputy speaker will also leads to the violation of this particular concept. And even either Lok Sabha or Rajya Sabha, so that we have been seeing a very frequent adjournments of these two houses. So regular adjournments disturb the smooth functioning of the parliament, and even misuse of money bill route is also another major cause of concern. And legislation not fitting the money bills category are often passed as such, bypassing Rajya Sabha. So these are some issues that have been plaguing working of the parliament. So therefore, what should be the way forward in this context? So we should also understand the appropriate way forward, right? So the way forward is, again, increase sitting days. There should be minimum number of sitting days. For example, 120 sitting days for the Lok Sabha and 100 sitting days for the Rajya Sabha, right? So that is very important. And in fact, parliament and state legislature should meet more often as recommended in the year 2001. And even training for the parliamentarians should also be provided. Particularly the professional training to the parliamentarians can be provided to improve the conduct and also promote the quality of discussions in the parliament. And even as of now, the privileges that are being provided to the members of the parliament are not yet codified. And in fact, a law commission way back has recommended codification of all these privileges. So therefore, codification of privileges will prevent the misuse of the privileges, and it would also ensure accountability. And strengthening of the parliamentary committee system is also very, very important, because this would ensure a detailed scrutiny of legislative and policy matters. And enforcement of a code of conduct, it is very important. So strict adherence to the code of conduct can actually limit the disruptions. Modification of Anti-Defection Act, so it should apply only when government survival is at stake. So remember that 52nd Constitutional Amendment Act has brought in the anti-defection law to prevent the political corruption and also horse trading and the political defection of the members from one political party to another political party. So we will later discuss about the anti-defection law, right? So in fact, it is very important to accord respect to the private member bills. This will promote a variety of ideas from the grassroots level, and even televise the committee proceedings so that the parliamentary proceedings could be watched by the public. And it is very important that the members of the parliament would feel that they are under the lens of the public, right? And in fact, transparency in clash of interests is also another major aspect. So interest articulation process should be more and more transparent and accountable. So it is very important to develop an index. So this index is called as the disruption index, because this index can actually monitor disruptions, and it could also check the indiscipline in the legislatures. So ultimately, in conclusion, you could actually write, it is important to preserve the democratic ethos. However, in order to preserve the democratic ethos, it is very important to look into or takes care the proactive and efficient parliament, and effectively involved in legislation, scrutiny and sessions. So in this context, a holistic approach towards political, economic, judicial and electronic reforms is necessary and important to enhance overall parliament's productivity, right? So that's how you could actually write a conclusion in the answer. And anyway, that's all in this lecture, and thank you so much. And in next class, we'll discuss some more important topics. So if you like our lecture, please subscribe our YouTube channel and also hit the like button. Thank you.